Welcome back to She Talks Law, a podcast by women for women, where we explore the intersection of law, leadership, and life through the lens of women in business. I'm your host, Jen Aronson, partner at Hodgson Russ. Each episode, we bring you conversations with attorneys, thought leaders, entrepreneurs, investors, and innovators driving change across today's entrepreneurial world. So let's dive in. This is part 2 of a 2-part series, and today we're joined again by the fabulous Renee Pardo. Renee is founder, speaker, attorney, and a coach dedicated to helping women redefine success, influence, and the next chapter of their careers. If you haven't already listened to part 1, I strongly suggest you do so, and then you come back for part 2. But in part 1, we tackled imposter syndrome and reframing it from prosecution to permission. Today, we're continuing that journey with a topic that shows up in every courtroom, every boardroom, and every negotiation table. And that's the difference between being assertive and being aggressive. This distinction matters deeply for women in law and women in business. Assertiveness builds credibility, it advances goals, and aggression, as we all know, can unintentionally damage relationships and trust. So to help us unpack this, Renee Pardo, who again is the founder, the speaker, and the coach, she helps women redefine success, influence, and the next chapter of their careers. Renee, welcome back to She Talks Law.
Thank you. I'm so happy to be here, Jen. Thank you.
Before we get started, I'd like to read your bio and reintroduce you to our audience. So Renee is a trial attorney and a speaker who helps high-achieving women stop prosecuting themselves for their past, their perceived shortcomings, and the case they built against themselves, and start living the rest of their lives like they've been acquitted. With more than 25 years of courtroom experience as both a prosecutor and a defense attorney, Renee brings a rare combination of legal grit, emotional insight, and lived truth to her message. After decades of winning cases on the outside while fighting a much harsher trial on the inside, anxiety, professionalism, self-judgment, she now speaks to women about the freedom that comes when you learn to feel anything, think on purpose, and step into the next chapter of your life with clarity and confidence. Renee is the current president of the Suffolk County Women's Bar Association and a member of the executive committee of the Women's Bar Association of the state of New York, which is how we met. In her law practice on Long Island, she continues to represent clients with the same commitment and compassion that have defined her legal career, while using her voice to champion women who are ready to stop putting themselves on trial and start leading their lives with authority. Besides practicing law, Renee is also a coach and a speaker and currently delivers her signature talk, Stop Prosecuting Yourself, along with workshops for women in midlife and for women attorneys of all ages. Okay, Renee, so let's start with the basics. How do you define assertive communication versus aggressive communication?
So thank you. What I will tell you is why this even came up, right? Why look for the difference, right? I've told you, it's important. You've just described why this is key and one is good and one is bad. This came up when it was very interesting. I was asked to do a workshop and a presentation by the New York Women Judges Association at Hofstra Law School.
Oh, wow.
So the reason that it even came about is that a student had written to a particular judge after she did some sort of talk and said, you know what? It was a female student. And she said, you know what? How are we supposed to ever be assertive in the courtroom or as an attorney when so many of us feel that we can't even stand up and speak in class when we don't think we have it perfectly? The guys just stand up and they'll say anything. And so many of us keep our heads down and don't say anything. And this really impacted this judge. And she was the catalyst that started the New York Women Judges Association on a project to, talk about it, bring them, all of them there to answer that question. And they ended up retaining me to make this presentation, right? So that was the catalyst. And they gave that question to me. And the very first thing I did was I looked up the definitions, in Webster's. What's the definition of aggressive? What's the definition of assertive? And it was not very helpful. It basically, could be almost in a way, they were almost the same. It didn't really say what the difference was. It was not helpful. And I'm like, why is one good? Why is one bad? So what I ended up doing was really went to the 30 years of experience I've had in the courtroom. And I also spoke to each of these judges about what they considered aggressive and when that was good or when that was bad. Because you often hear the criticism, women need to be more aggressive, and that they're not saying it as a bad thing. They're saying women should be more aggressive in the courtroom. Well, do we want to be aggressive? No, you need to be assertive. Like, what's the difference? So I realized after listening to what various attorneys, judges said about assertiveness or aggressiveness from a good standpoint or a positive standpoint that helped their client or their case versus a negative, that assertive is really any behavior that's goal-oriented. It's the person or the attorney that's saying, I don't believe that the law takes that route. I don't believe that that's the position. This is what I want you to hear. This is what I want you to believe. It creates space to basically advance your case, to point out exactly what it is you're there to do. Aggressive, and when we're talking about it, the more negative, is all about the speaker, the attorney. With all due respect, counsel and focusing on what the other party is doing wrong or why they're not as strong rather than the facts of the case, right? It's aggressive in the negative way when it's looked at as negative, is like driven by personal feelings or reactions rather than the priorities of the case. And a lot of times we've all seen it, right? We've all seen it. We all may have experienced it or done it. Like you mentioned, Jen, you were like, in the heat of the battle, it can happen. I'll give you an example. You find yourself, your opposing counsel has, objected to certain kind of question that is proper over and over again. You've had this battle. Then you pass the baton, right? It's their term. If you have that feeling that you want to do it to them, not because you need to stop that particular bit of information, but you want them to know what it feels like, that's aggressive. Now, in the heat of battle, these things are normal. I'm not saying that makes you a terrible, aggressive attorney that's no good. But it's a great way to explain the difference. Assertive is, you know what? I can let that all come in, but when it's time to make that objection, I'm going to do it properly for this reason, rather than being about damaging a relationship or credibility, or I'm going to do it to you because you did it to me. I think that's a good way to sort of describe that dynamic.
Absolutely. And with being assertive, shifting the conversation back to the issues, back to the facts, the circumstances, rather than focusing on the other person and trying to depreciate their credibility.
Absolutely.
If you just rely on the facts and circumstances, sometimes that depreciates the other side's credibility in and of itself.
Absolutely.
And if the other side is also showing aggression, I would think in my mind, if you ignore that, well, not even ignore it, but try to reframe the conversation back to the goal-oriented, assertive communication rather than the aggression, and sort of letting that aggression fly. Just let it happen, let it flow through you and let it happen. That's been a tool that I found to be really helpful when I'm negotiating a deal is, if the other side is really being aggressive on a position and I know that my client is not in favor of that position, knowing that if the other side starts, using attacking language or raising their voice or anything like that, taking a breath, grounding yourself back in the facts, the circumstances, and also going back to our last conversation of talking about, having the confidence of knowing those points, those brain anchors, going back to those brain anchors to really help guide you in the conversation, I think is absolutely critical.
That's a perfect example because it's so easy for me, especially to think of the trial situation, but negotiation settlements. I mean, I work on that with many of the attorneys that I coach. I mean, just remembering to go back to talk about, framing arguments around fairness and around the law and outcomes that are going to be helpful. that is such a difference. Rather than just making arguments about, to show your dominance in the situation.
Mm-hmm.
When you hear that lawyer, I've been doing this 30, that is not about the case.
Right.
That's about personal situation and never feels good. And it doesn't impress anyone.
No, it doesn't. I'll never forget I was in a negotiation, and this was, it was earlier on in my career. And the attorney on the other side had been practicing longer than I had. And he turned to me and he goes, "Now, young lady, let me explain to you something." And he used the term young lady. And I don't think I caught anything he said after that besides being incredibly offended that he was diminishing my position by just calling me young lady, as if I didn't deserve to be at that table, or as if my opinions didn't even matter. But it was almost like debilitating in that moment and paralyzing, because I thought, oh, wow, am I not good enough to be at this table? Am I doing something wrong? So I started questioning myself. But that was almost I don't know if that was aggressive or passive aggressive or what that was, but by him just saying those two words, it totally threw me off. And I wish in that moment that I had the tools to know how to reframe the thought process, go back to that assertive communication, because I could have just stopped him and said, nope, let me finish what I'm going to say, and then I'll let you state your position. Yeah.
Right. Yes. And, part of me would love to have said that what you should have answered if in a perfect world was, well, I understand that you're old and you've been doing this a long time. But honestly, that's also aggressive. Like the point fully is just, that is it.
And trust me, I wanted to say that.
Yeah. I've been in a position in trial where I snapped back in those ways.
Yeah.
Super good. But I guess the point is, it's okay if that happens to you. It is going to, certainly in the heat of the battle. But if you always remember to come back to what you're trying to accomplish, you won't go wrong, and you'll get a reputation no matter what. People don't always love you, right? It doesn't matter if you're the most wonderful, juicy peach in the bushel, right? Some people don't like peaches. But you can get a reputation, and this is what we got across to the students in that Hofstra class. You can get a reputation as being, the person that always knows how to talk about the issues, the judge or whomever you're in front of, even if it's a client or it's in negotiations, knows that you're going to do your best job. You're going to have a cool head, and it's not going to become about you. That can last you a reputation that will take you wherever you want to go in your career. And that's who you want to be.
There are certainly attorneys that that when you get in the negotiation table, it's going to be a battle, regardless of what it's about. It could be about the color pencils or colored pens that we use to take notes at the table. But, there are certain people that have that reputation. It's damaging for the rest of your career. It really is.
Absolutely. I agree. Yeah.
Yeah. So can we let's talk about some examples, like real world examples. Can you share a courtroom example where assertive communication may have protected a client's interest versus a time when aggressive conversation backfired?
Well, just like what we've already talked about. It's hard in the heat of the battle to not make it somewhat personal, but that's what you have to remember. I guess the biggest example I could think of, in my own career, and like there were different experiences when I was a younger attorney as opposed to much later in my career. But I would say, I have been in a situation before where, I was objected to over and over again for something that I knew was proper. And it was really presented in a way to throw me off kilter. Like, for instance, objecting in a closing argument. Obviously there are things, particularly as a prosecutor, that are improper. And
for our listeners who are not attorneys, can you object in closing arguments?
So you can. I don't want to say that you can't. You absolutely can. But here's, and as a defense attorney, I do defense work now, you've got to protect the record. So if the prosecutor is doing something that it is objectionable or that you could argue is, you want to protect the record. Totally understand that. Sometimes though, particularly as an assisted DA and in a particular case that I'm thinking about, I could tell, or I felt, even if I was wrong, that it was done with when I was just building a crescendo. So like to stop me from there. And I could have, I think when what you asked for was an example where it would protect the interest. I had to focus not on myself. It's the same tool. I had to focus on, okay, I'm not going to get lost. And even in preparation with my closing, right? And it's a long closing. It's a 3-week trial. It went on. I set up brain anchors. This is what I'm going to talk about first. Then I'm going to talk about this. Not read it line for line. These things. And I just had to, when he would object, I had to remember I'm right at the point where I'm explaining all of the things that didn't make sense when his mother testified, why I was showing she wasn't credible, right? And I was being objected to. It would have been so easy to be like, anyway, what I'm telling you, couldn't do that. I needed to make those points. And so what I did was just remember, I'm here. Let him object, let it get ruled on. And guess what? I knew that the objection was not going to fly. I was allowed to continue, but he wanted to throw me off, or at least I believe that, but I wasn't. And the brain anchor was there. I'm at this point. What I was saying, ladies and gentlemen, is this. And if I could keep my cool and remember, this has to come out. It may not come out exactly perfectly because I'm getting interrupted. This is something that's going to keep happening. But I'm going to keep my cool. And you know what? Later on, and this is why I believe it answers your question in terms of protected, the jury saw it. Because when I got that guilty conviction, the jury was able to talk to me after the whole trial was over. And one of the things they said is, we saw what he was doing there at the end. And we saw that what we wanted to, you know, that when you've got 12 people and 2 alternates nodding along with you when you're trying to get it out because they don't want you, you know, you got them, right? So I think just keeping in mind, this victim deserves for me to tell this story at the end and how it came out. And no matter how many times I'm objected to, I will get it out. And I don't have to get it out by shouting or turning my argument to him and going, this is it. Just do my job. So that's an example I have for you because that is the world I was in. There are lots more examples that come up in other types of situations. That's one that I felt personally, so it's so easy for me to talk about.
Yeah, and it also comes up, as we've sort of discussed before, in negotiation settings in more of a transactional world, right? So we can use assertiveness to help us frame arguments around fairness and around outcomes.
Right, exactly. So, you know, when you want to be insulted, you're not thinking about the outcome, like you just said. When you want to be offended, you could be as offended as you want, but you've got a job to do. And you don't want all of those things to distract or take away. And when you think about that and know, I'm going to give my brain time to freak out about this later. I'm going to, complain all I want. But right now, I don't want to just react. I want to be strategic. That thought helps me. It gives me so much power. I don't know what it is for you or other attorneys. I know when I work with clients that are attorneys that want to be more assertive, they want to be less afraid of the things that will happen in the heat of the battle. That's what we look for them. You know, what's going to keep them grounded, no matter how nasty it may get, right? And the outrage about the nastiness, you can have that, but not then.
Part of the way, and I was meeting with a client the other day and they asked me, so what is your style? What is your negotiation style? And I thought that was a really interesting question because it reminded me of the dichotomy of having somebody. You could either have somebody who really is a bull and is really aggressive and just kind of pounds their position down another person's throat versus somebody who is more assertive and more seeking fairness at the table. Being assertive doesn't necessarily mean that you're not going to advocate 100% for your clients or that you're not going to take the most advantageous position possible for your clients. It's just about how you approach the negotiation itself and how you approach the other person and respecting all of the parties at the table. part of what I love about doing transactional and corporate law is that everybody really wants the same outcome in the end. If you think about it, everyone just wants to get to closing. So if we can go back to the basics and really reframe our mindsets around that, I think it would be really helpful, and might help to some degree, maybe ease up on some of that aggression. But some of that aggression is just innate in other people. And what I'm curious to hear is, I want to know, I know that there are some things that I see and I automatically think, oh, that's an aggressive person. That's an aggressive communicator right there. But what are some common aggressive tactics that you've seen? So, I've mentioned intimidation and dominance, but
Right.
what are some of those tactics and why do they often fail?
So we all have seen it, right? It's really it could be anything from somewhat of like what was made to you, almost a degrading or a way to insult you, or maybe in a backhanded, passive, aggressive way. Those are things that often come up, right? In lots of different settings. I think one of the things that you just said before, if a client asks, what is your style? I think oftentimes, now that's not everyone, I don't want to make complete generalizations. What's so great and why women can be such skillful negotiators and so skillful at this is because if you have even a smaller degree of emotional intelligence, your answer for that would truly be, it depends on the situation. Like, I know you well enough, Jen. I've seen you in, women's bar meetings. We've been there together. You're going to answer or voice your opinion depending on the situation and what's called for. You're not always going to be a bull in a china shop, but if your position is not being listened to, you step up the volume, right?
Right.
And having the ability to do that is tremendous. And we also know some attorneys, some women attorneys that are soft-spoken, they never raise their voice. That's not me. There's nothing wrong with that. You know your style. You could be assertive or in any kind of style. And what tactics you use or how you respond could very well be, if you're truly good at it, dependent on the situation. What does the situation call for, right? So, that's interesting. I'm curious what you gave as an answer. Well, this is my style. Because truthfully, to me, if someone asked me that question, I would have to say, it depends on what the situation calls for.
And that's really what I said. Yeah. I said, listen, I'm not going to be the kind of person that's just going to attack the other side just for the heck of it. I'm going to obviously zealously represent my client. I'm going to stand strong to whatever position the client has. But at the end of the day, I think approaching a negotiation in a respectful manner is going to get you a heck of a lot further than it is if you are trying to be aggressive and mean and demeaning to the other side just because they have a position that's contrary.
Absolutely.
So I'm in much more of a collaborative mindset. Let's get to the end collaboratively, even if we're on the other side. But that doesn't always work, I understand. But again, and as you were saying, it depends. It depends. If I have to turn up the volume or get more aggressive, I will.
Yes.
But there's a time and a place. There's a time and a place. Yeah.
Agree. Yeah.
Mm-hmm. Yeah. So could you walk us through some anecdotes, maybe even from your coaching experience, that illustrates the difference between assertive and aggressive approaches?
Well, again, I think this is all what we've been talking about, right? It's the same thing. It's rather than saying that's the weakest argument I ever heard and doesn't take into account blah, 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 blah. Your Honor, that's not what the law actually reflects. I'd like to show, there's a way of speaking and showing and getting back to the point that you are there to litigate, if we're talking about litigation. In other areas, again, you mentioned framing the argument around the outcome. Going back to, why should my client have to do this, this, and this? Nobody's taking into account. He's had to be back here 3 times. Your client hasn't had to pay any of this, blah, blah, blah. What is the outcome we want? We want something that everyone can live with and where, whatever the example was, and where the child feels most protected. Or we want to reach an agreement where, this is not going to continue to cost my client this amount of money. So those are all things that when you go back to the point of the outcome you want, you're going to be much better off. If you are dealing with someone who doesn't want to talk about the outcome, but is just arguing against you or arguing against your client, and how that is very difficult. At some point, to give you an example, you might give them the space. Now, you don't want to do this in certain settings because it could be damaging. If you're in front of a judge and you want to have them hear all this, you might want to give them the space to go ahead and let it all out. And then simply ask the question, so where we are now, having said all of that, and I'm not going to argue with you, where we would like to go now, like just constantly going back to here we are. This is where we want to end up. Sometimes you find out that all they wanted to do was really vent and for the client, or maybe
this
it's
is
the
no different than my 5-year-old having a temper tantrum, by the way. Just the best tactic, rather than trying to get them to stop and get them to stop being so upset. Sometimes the best tactic is just letting them let it out.
Right.
And then when they're done, then you come back to it and you revisit it.
Right.
Yeah.
You can't do that in front of a jury. You can't have them hear, like, you got to protect your record. I get all that.
Right.
But sometimes that could be in chambers conversation, or it could be, okay, let them talk about why everything has been unfair against them and why they don't think it's right and all of that. Okay. Not everything needs an answer. And the answer to that is be strategic. And if it's not about your ego, it's about the case, that's a lot easier to do.
Yeah. Let's talk a little bit about over-responsibility.
Sure.
Women taking on too much personal responsibility for outcomes. Why do you think that happens so often?
Well,
or explain a little bit more, I guess, before we go into why. Explain more about personal responsibility for outcomes. Yeah.
So it sounds like you're just doing the right thing, right? You're over responsible. You take responsibility. It's a good thing to be responsible and to not pass the buck. What I refer to when I'm speaking about over responsibility is I have attorneys who want coaching who will come to me and they will be, for instance, talking about, I'll give you an example. I think it's the easiest way. I had an attorney who, an immigration attorney. I mean, they're under tremendous amounts of stress right now, right? Mm-hmm. Dealing with situations where sometimes they don't even know where their clients are, and the rules keep changing. It's it's a lot to take on. So, I had one particular client who would talk to me about how, a particular client committed a petty offense, and then that ended him up in this situation. And then she wasn't able to bring up, X, Y, or Z. This is what's going to happen. He's going to end up being deported. He's now can't provide for his family while he's in custody. We don't know what the outcome is. All of this was true, and it was a big burden, but it forgot the part where he made certain choices. It forgot the part where she cannot be responsible for as much as you could feel. And I didn't tell her not to feel bad. It wasn't fair. It wasn't right. But it was not her responsibility to be so worried about what was going to happen. She's human. She doesn't want to feel good about it. But it wasn't her responsibility to take on that the entire future of this family was on her shoulders. And that's how she felt. She says, but you don't understand. But I do understand. I could give you a whole other context why that victim I talked about that's 10 years old, it's not, but that doesn't take into account that we didn't create these situations. Right. And, it can make you feel awful and it can make you feel bad. And there's a time again for that, because do we really want to be a human that is callous and doesn't care about that? No. But it's also when you take that on, yourself as I am the only thing standing. And that's what she would say to me. I'm the only thing standing between them and getting shipped off to wherever and their families falling apart. No, you
That's
can't.
A lot of weight to bear.
It's a lot of weight to bear. Now, I understand she feels that way, but we really had to move her towards this is a very difficult situation. It's not one that I created. I can use every law and everything that I've learned over my career to do the best for these people that I can. These are my clients. I care about them. I can also make sure they understand what's going on, what I can do and what I can't do. What I cannot do is worry about their future for the next 30 years in this moment, right? At the same time that I have personally have the responsibility of making sure that my child's permission slips are all signed, that I know the exact schedule that they're going to need to have for the next week, that I don't forget the parent-teacher conference, that I pack the lunches. Also, that I make sure that I am part of this volunteer group in the neighborhood because I said that I would do it. So when we start doing all of these things and we're at work and we're thinking about how we're failing at home, that leads to being at home and thinking about how we're feeling, not doing what we need to be doing for work. Okay. It's too much. And so many of the women that I have coached or listened to have this over responsibility. And that's what I'm referring to when I use that term. It's the worrying about one thing when they're doing another, and it's just overwhelming.
That mental load is a term that I've heard quite a bit. Carrying the mental load, thinking about everything that needs to happen and always having it top of mind.
Yes.
And then also putting a lot of pressure on yourself if one part of the puzzle or one piece of the puzzle drops, and taking responsibility for the entire fallout from that piece of the puzzle dropping while still trying to hold up the other end. It can be a challenge. Definitely. Yeah. And so how does over responsibility hinder assertive communication?
Well, if you are mired in what you just described, if you are mired in being at work, worrying about what systems you should have in place but don't at home and it's all on you, you're much more likely to miss the opportunity to have that clarity to put forth your case. I mean, it's just a matter of your brain can only take so much, right? We talked about brain anchors before and in the other episode, right? We talked about little ways that you can keep yourself online when, everything is going on around you. Well, you can't do that if you're responsible for the world and you're worried that you're failing at it. So you miss things. You're actually of no use to your client. You're of no use in the business world if you've got that. One of the ways to combat that is to do what you can, and not everyone can do this, but to really have systems set up. Is there a way that you can get more support? If it's at home that you're worried about, is there something that somebody else can be responsible for? Or is there a way maybe that your standards in terms of course you want to take care of your children, of course you want to, participate in their school activities, but is it really necessary that you make the cookies or the cake from scratch? Or could you perhaps, buy one? Or maybe you could speak to another mother about bringing something in for you. You won't do that every time, but in this particular season, you've got X, Y, and Z going on at work. Like, are there systems? Sometimes we're our own worst enemy in terms of, no, I can't do that, without really thinking it through. I don't really...
You have that perfectionist mindset that creeps in.
Yeah, it's a big problem. So sometimes it's looking at the systems you have in place and being realistic about where you can do less so that you can focus more where you need to. Sometimes it's about, well, I will do the best that I can here, but right now I'm focusing on this. And that's really the answer. If your mind is elsewhere and you're just mired in the over responsibility and you're not up to par and you've got that going through your brain, you are going to miss the opportunities to do what you need to do in the moment.
And probably burn out.
Absolutely.
honestly.
Feel
Yeah.
horrible the whole time. And your brain is giving yourself evidence that what you're telling it, how you're not good enough, your brain's going to find ways to show you that you're not. Absolutely.
Yeah. So, can you share a simple exercise, or do you have a simple exercise for reframing a statement from aggressive to assertive? Can you give us some examples?
I think I sort of have when I explain it. To me, one of the best examples is, that's a ridiculous argument, or that's not accurate. Even saying that, just being able to say, what the law shows, Your Honor, is this, to negate what you just heard that is completely, instead of saying something that, attacking the person or how they did it. It's funny because, again, I think I mentioned in the last episode that I had done a program recently with the New York Women Judges Association. One of the first things the judges talked about, I was joking, but it was when they were discussing with me is, hearing that with all due respect, Your Honor, which was really a way of saying you're absolutely incorrect, just, so a way to change that, because as soon as they would hear that sentence, these female judges that talk about that, even to them, they feel sometimes they're just being aggressively attacked, is, Your Honor, what I want to say is that these three cases say something else, like just in some way of not, with all due respect, which we all know what that means.
Yeah.
So that's an example that we hear all the time, just in changing that. Even saying something like, respectfully, Your Honor, I don't think that's what the law holds there. I would argue, even that reframe, you can then get into what you want to say. And you can assertively do that. Right?
Contrary to what counsel is saying.
Yeah.
Yes, you hear it all the time.
Yes. And even that, depending on how you say it, may or may not be so, it could also be an and sentence. It could be something like, and if that is true, that X, Y, and Z is so, then blah, 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 blah. And what's also true, Your Honor, is that my client did X, Y, Z, and has already exhausted that. Like an and sentence can sometimes help with that. Yeah. But again, if you can't worry about how you are going to do it beforehand, because you don't know what's going to come at you. So really what you need to have in your head is that I got to advance this case. I'm going to make my point. I'm not going to just shrink. But I don't have to do it in a way that's disrespectful to anyone. And if they're going to be disrespectful, let them. It's going to help me because it's going to show how much more professional I am. My argument is going to be listened to over that overbearing argument that is just based on demeaning me or my client.
And that person's going to diminish their own credibility by acting in that way.
Absolutely. Yeah.
If our listeners remember one key thing from this episode, Renee, what would it be? What do you want them to take away?
What I hope they take away is that if you've got those thoughts, if you listen to this and go, oh my gosh, I do that. I shy away from taking, bigger cases, or I shy away from that. Understand that what's going on is completely normal. It's okay. Though that fear, that doubt, that is your survival brain. That's your brain keeping you from the cheetah. I mentioned that in the last episode, that's chasing you. Your brain doesn't know the difference between opposing counsel and a bear going to eat you, or a dinosaur, or whatever. It's the same mechanism. The point when you feel that or see that is to realize, I'm going to feel those thoughts and I'm going to act anyway in a way that's going to advance what I want, that's going to serve me. I can come up with at least one thought that's going to serve me. I don't have to stop thinking. If you've been thinking for 10 years, I don't really know what I'm doing with this kind of case, you can't just stop thinking it. It's like telling yourself to, stop thinking about a pink elephant. Whatever you do, don't think about a pink elephant. All you can do is think about a pink elephant, right? That's your brain. What it is to I'm going to think about the pink elephant. And then I'm also going to think every time that happens, this other thing, something that moves you forward. It's got to be something you believe, not the fake it till you make it, but one thing that moves you forward to your objective. And that's what I would say. Know that if this happens to you, this is normal, but there are things you can learn to do, techniques you can learn to advance your position, to advance what you want that serve you rather than keep you in that circle of doubt and fear.
Like using some of those brain anchors to advance
Absolutely.
yourself forward. Yep.
Right. Yes.
One step at a time. Yes. Well, thank you so much, Renee. I really appreciate you being on today.
You're welcome, Jen. Thank you for having me.
Renee, thank you for helping us break down the difference between assertive and aggressive communication. I love the reminder that assertiveness is still advocacy. It's about advancing goals, creating space for what matters, and not overpowering or reacting. To our listeners at home, be sure to visit reneepardocoaching.com to see if working with Renee is right for you. Don't forget to subscribe to She Talks Law on Spotify or Apple Podcasts. Like and follow She Talks Law on Instagram and Facebook. And email your comments and your topic suggestions to me at jaronson, that's JARONSON, at hodgsonruss.com. We'll continue exploring the skills and mindset shifts that help women in law and business thrive. And finally, the views expressed on this podcast do not reflect the views of Hodgson Russ and should not be construed as legal advice. This podcast is not intended to create a lawyer-client relationship, and listeners should not act upon anything expressed by presenters without seeking professional counsel. This podcast may constitute attorney advertising under various state ethics rules, and we note prior results do not guarantee a similar outcome. I'm Jen Aronson, and this has been She Talks Law. Remember, permission over perfection and assertiveness over aggression. Until next time, keep leading with confidence and clarity. Thank you.